broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to SCA, DBA, and CBAs, where labor law and government contracting collide. Excuse me, it is 2 o'clock. I am Nicole Attell. I'm a partner here at Palermo. I'm here with my colleague, Sarah Nash.
Hi, everyone.
And we are excited to bring you the second in our three-part labor series. Last week, if you were with us, we talked about kind of the nuts and bolts basics of labor relations. And hopefully, for those of you that attended, you got a lot out of that. That webinar is available for those of you who still would like to look at that. If you are not familiar with Palermo, I know we have some newbies this week. We are a full-service law firm in Washington, D.C. Many of our clients are government contractors, which is why we are covering this particular topic today. But in addition to our labor and employment practice, we have a robust government contracting practice, litigation practice, and corporate practice. So let's dive right into today because we only have a half an hour, so we are going to waste no time. What are we going to learn about today? Today we are going to talk specifically about the unique labor law requirements that apply to federal contractors, particularly when it comes to service contracts and construction contracts. There are some other labor relations type stuff that apply to just general professional services, etc., but they pretty much line up with labor law commercially, so we're not going to cover that in depth today. We are also going to talk about timeliness issues with respect to getting collective bargaining agreements turned in, what types of things you should be paying attention to when you bid on a contract that has a collective bargaining agreement attached to it, and how to identify the impact on your company if you're considering taking on one of these obligations. We wanted to talk a little bit about the differences between the DavisBacon Act and the Service Contract Act. So the DavisBacon Act is really contracts for construction if you're not familiar with it. It can also be alteration or repair, and you've got to pay no less than the prevailing wages and fringe benefits. The service contract is similar in its requirements, but it applies to service workers. You know, we're thinking janitors, nurses, admin staff, those types of non-exempt folks. What you'll see today is that we will be talking a lot about the Service Contract Act, particularly because there's a section of the Service Contract Act that governs how collective bargaining agreements are worked into your federal government contracts and how you need to, it impacts how you then need to negotiate and timing with the union. The DavisBacon Act, on the other hand, those prevailing wage rates that are in the wage determination itself usually encompass the labor rates prevailing in those localities and usually cover what you would pay your bargaining unit if you have one. The difference is really that under the Service Contract Act, you're picking up generally a whole workforce from an incumbent contractor, whereas the DavisBacon Act, because of the nature of the work, often those workforces are already with you, or you're picking up folks that already have those prevailing wage rates in the region. So you're using the wage determination as opposed to picking up an entire collective bargaining agreement that's attached to the contract. Every now and then it happens in DavisBacon, and we will be talking about DavisBacon with respect to price adjustments and what types of costs you can recover. So I hope we haven't lost any of you construction folks out there. And you should also pay attention because sometimes, more often than not, the Service Contract Act and the DavisBacon Act can be in the same contract. And so it's important for you to understand if you have some painting work or repair work, what might impact you.
Right. So as Nicole mentioned, we're going to, a big part of the SCA involves collective bargaining agreements. There's actually a 4C section of the Act that specifically discusses contracts where you come on and there's already a union on site, which is why it's particularly relevant in the SCA world. And when you're looking at wage determinations under the SCA, which are essentially what's telling you what the wages and fringe benefits of the employees, what they have to be, you're generally, for the most part, going to be dealing with two different kinds of wage determinations. The first kind is perhaps more commonly known, and it's prevailing wage determinations, and that's based on specific geographic localities where they're looking at what's the prevailing wage that employees are receiving. And these are based on a number of factors, including surveys and just other research that DOL does to figure out which particular classification fits in what wage rate. And then you also have fringe benefits, which are standard. We just got a comment that there's a problem with the sound, so hopefully you can hear a little bit better. We'll try to enunciate as we're speaking. So you have wages that are going to be set by a prevailing wage, and then you also have fringe benefits, which is essentially just a rate that's based across the country. Some variations might apply for certain benefits. Holidays, vacations can vary, and then in Hawaii you have some different rates just by virtue of them having healthcare that's provided. So that's the prevailing wage rate. Wage determination. Then you also have a wage determination that's based on collective bargaining agreements that unions and predecessor contractors have agreed to. So basically what happens in that scenario is when a new contractor comes in and bids on a contract, if everything's working and all the nuts and bolts are in place, the CO or the agency will include a copy of that collective bargaining agreement in the bid or in the solicitation. And so you should be able to essentially look at that collective bargaining agreement and be able to bid accordingly. And there's some specifics that we'll go over as we get into the webinar, but that's sort of the two different wage determinations that you're going to come across. And obviously for the purposes of this webinar, we're going to focus on wage determinations that are based on CBAs.
So the first thing we want to do is kind of walk you through the life cycle of how you're going to run across these things, right? So the first thing is that you're going to look at a solicitation and decide whether you're going to bid on it. And you look in that solicitation and you see that there's this collective bargaining agreement attached to it. So what types of things should you be paying attention to at this point? What you don't want to do is just assume that none of these wages or fringe benefits will apply to you. 4C requires that that collective bargaining agreement, even though you're not a party to it, is the prevailing wage rates in that locality for the base year of that contract. Not going past the base year, but for the base year of that contract. So you want to take a look at that CBA and read it very, very carefully. Any wages, shift differentials, health and welfare, healthcare, pension, funeral, jury duty, retirement, pension plans, all of that stuff are costs that you're going to have to bid in. There may be costs in there that you should not bid in, or you should think about whether or not you're going to bid into it, right? Because the government generally doesn't want to pay for those things. Occasionally you'll see overtime requirements, double time for overtime. If you don't have a line item or you don't think the contract calls for overtime, the government's probably not going to pay for that stuff. Boots. Sometimes you'll see a little wonky, you need to pay this many dollars for this and this many dollars for that. You really have to think about whether that's something that can be covered or not in what you want to bid. Because you may not have an obligation on day one, if you are awarded the contract, to pay those types of benefits. You do have an obligation to pay the wages, fringe benefits, et cetera, that are listed here. You may not have an obligation to pay for those other things. You also want to make sure that you're carefully paying attention to any referenced retirement plan or pension, because there is a body of case law out there that says the exact amount does not necessarily have to be in the CBA. If there's a reference to something in that document that indicates to you that there's another document out there that covers some sort of wage or fringe benefit, that's a pre-award protest / Q&A type question, and you have a responsibility to figure that out at the solicitation phase.
You also want to, Nicole spoke briefly about the case law attaching to retirement withdrawal liability, but remember that you don't actually have to bid the specific fringe amounts or benefits that are in the CBA, just the amounts. And so at least at this stage, you're not as worried about signing on to pension funds, although I mean, chances more likely than not, the union's going to ask that you sign on to their pension plan. So it's a good thing to be thinking about, but not necessarily needed at this stage.
All the SCA requires is that you look at the value of wages and fringe benefits and you provide that value. So you could say, okay, well, we've added it all up and this is what we think the fringe rate is, and we are going to provide X amount in health care, X amount in 401k match, et cetera. But you don't necessarily have to exactly line up, as Sarah said, the benefits that the union provided. Again, you are not a party to that CBA yet, right? So really this is an SCA issue as opposed to a collective bargaining issue. It is a good idea to think about what you might agree to and what you won't, because as Sarah alluded to, the union's going to dig their heels in on a couple of these things.
And we received a couple of questions about unclear CBAs and how you can go about seeking clarification, especially perhaps when the union might not be available to answer questions about what certain terms mean. Sometimes you can submit a Q&A asking if the agency has an idea, and they might have some better resources to be able to find out that answer. But often, yeah, you're going to come across CBAs that aren't necessarily clearly written, and there is some ambiguity, and it's difficult to figure out what the clear answer is.
Yeah, and if you can't get a response from the CO, that you have an obligation to pre-award protest it. And that could just be as simple as a letter to the CO. But you need to address it then. It's like any other ambiguity in a solicitation. If the ambiguity is there on its face at the outset, you have to address it before bids go in. So let's talk about a quick scenario. Basically, you receive a solicitation. It has a CBA in it. The contract, you get the contract. Great, you bid it. Fantastic. You begin work and the union contacts you and advises you that you need to pay into the pension fund. You tell the union there's no rate for the pension in the CBA, therefore you're not paying it. The union claims the pension was referenced in the CBA. You offer to negotiate it next year. Sarah, are you correct?
If it's not in the CBA, then you do not have an obligation to pay it.
But I would go back and check to see if the union's right and if it was referenced or not, right? Because if there is some reference to a union pension plan and that there are rates in that pension addendum, then you would have an obligation because it would be unclear. But Sarah's right. If it truly isn't in there and the union is incorrect, then it's fine. If you submitted a claim to the CO and there was an ambiguous term in the solicitation, and then you go ahead and submit a claim for a price adjustment, your chances are very low that you're going to receive a price adjustment because the CO is going to say, no, you should have known it when you bid. And there was an ambiguity there that you should have resolved. Okay.
So let's get into some of the obligations. We talked about bidding and some of the requirements and what you need to be looking out for. But let's say you've actually won the contract. Great, congratulations. And all of a sudden, you're in charge of this workforce that happens to be unionized. So what are your obligations? So this is sort of an interesting part of the law where you have overlap between the Service Contract Act and the National Labor Relations Act. And it relates to successorship obligations. A successor is essentially a contractor who comes in and has substantial continuity in business operations as the predecessor contractor did. And the majority of the new employer's workforce is essentially hired on by the successor, by the new contractor. And because there's this non-displacement of qualified workers under the service contract requirement where successor contractors are obligated to make offers of employment to the incumbent workforce, generally when you come in, you're going to be operating in this successorship dynamic where you have hired a majority of the workforce from the predecessor contractor. Everybody's probably familiar with that general idea. And the idea is when you are a successor, you have an obligation when you get onto a work site to negotiate and bargain with the union. And this is actually something that applies in the government contracting world as well as outside. So even if you're in the private workforce, if you come in and take over and hire the majority of employees, you have an obligation to bargain with their chosen collective bargaining representative, the union. You want to remember, however, and we talked about this earlier, you do not have an obligation to sign on to the CBA that exists when you get there, that was between the predecessor contractor and the union. Because of the SCA, you have an obligation to pay the wage rates and fringe benefits, but all the other terms, seniority rights, work rules, work schedule, grievance procedures, job security, you essentially have the ability to create new terms and conditions when you get on the work site.
And there was a question that came up that was basically, well, what if there is a medical benefits plan description that's not included in the solicitation? Well, the question is whether the value of that benefit plan was in the CBA. So if it said you're going to pay $1,500 a month per employee for family health care, that's really all you need to know to bid on the contract. Then later, when you get to the stage that Sarah's talking about now, when you're trying to decide what your successor obligations are and what you're going to negotiate, that's when you would ask the union for their plan descriptions and try to make a determination as to whether you would agree to sign on to their plan or not.
Exactly. And sometimes you're going to be in a situation where, I think we'll talk about this a little bit later, but where the union's going to want you to sign on to a bridge agreement. So they might, for the sake of employees, want you to sign on to that pension plan and want you to sign on to the medical benefits plan, just so that in the interim, when you are negotiating a CBA, employees aren't left without those benefits. And in that instance, you can sort of evaluate whether it makes sense to sign on to those pieces. So you have that opportunity, but it's not an obligation. There's sort of a quirk to the labor law that applies here that it's important to understand what it is, and it's a caveat for perfectly clear successors. So in the previous slide, we discussed what a successor is. In the world of the NLRA, there is also something called a perfectly clear successor, which is a new employer has either actively or tacitly misled employees into believing that they would be retained without a change in their terms and conditions of employment. And when an employer fails to announce clearly that it will be establishing a new set of conditions of employment, then it runs the risk of becoming a perfectly clear successor. So what? The problem is when this happens, if you are found to be a perfectly clear successor, then you have an obligation to essentially sign on to the predecessor's CBA, which includes sometimes a bunch of terms and conditions of employment that aren't necessarily workable within your chosen business plan. So you want to make sure that when you do first meet with employees and you do have that opportunity to come in and introduce yourself, that you're making clear that there's new terms and conditions that you're going to be applying.
Yeah.
Otherwise, this could be applied.
Yeah, so you can say, you're going to get that same wage rate for the first year, and and we will meet our fringe benefit obligations under the SCA, but we are not guaranteeing that we are going to agree to the same terms and conditions as the last employer. And of course, we're going to negotiate with your union or your representative in good faith, and we're going to sit down and talk, and everybody's going to be happy. But we're not signing on to the last CBA, so we just need to make that clear.
And so Nicole just touched on this. I'll go over this slide pretty quickly. We talked about it last week. But when you do enter in as a successor employer and you have obligations to bargain with the union, there's a few important sort of rules that you need to remember. First, you have an obligation to meet at reasonable times and confer in good faith with the union on mandatory subjects of bargaining. And next week, we'll talk more about sort of the rules and good practices that apply to collective bargaining. But for the time being, just keep in mind that that's an obligation that the employer has. And this duty to bargain includes a duty to deal with the designated representative of employees, to provide, if needed or requested, information related to wages, hours, other conditions of employment, and to make sure that you're not making, while you're negotiating, unilateral changes, which is essentially a change that you've made without giving notice to the union or asking permission from the union to make that change. So just bear in mind that this applies more broadly to employers across the board, including federal contractors, but it's just something to keep in mind. And now we'll speak a little bit more about the specifics that are required of federal contractors.
Yeah, so there are rules of the road with respect to negotiating, which we're really going to cover next week. So what we wanted to talk about today was what stuff is really important when you're talking about negotiating a CBA with the union on a government contract. And the first thing we need to think about is timeliness, because when you show up on site, you are going to negotiate your own CBA, and maybe you looked at the old one and you say, you know what, we're easy peasy, great with everything that was in the old one. We'll just sign a bridge agreement and everybody's hunky-dory. But you need to keep in mind that that CBA that was in that solicitation is really only covers the wages and fringe benefits for that particular base year. Even if it had rates in there for the out years, one, if you bid those out years, you might have lost your right to get a price adjustment under the price adjustment regs, which we'll talk at the end. So generally speaking, you only want to bid as a general proposition that base year anyway. And two, you really don't have some of the protections in that CBA unless you've signed on to it. Primarily for employers, that's the strike provisions, right? Where we say nobody's going to strike and nobody's going to lock out, right? And so if you haven't signed on to your own agreement, you don't get some of those protections. And the union doesn't have the grievance and arbitration provisions, which is kind of something they want. You have an obligation to begin negotiating in good faith right away. That said, you don't technically need to turn anything in to the contracting officer for almost a good year after that base year. But it's really critical that you have a signed, sealed, delivered, ratified, great CBA into the contracting officer. What we like to say as a general rule of thumb is 30 days before your next option period. Now that is conditioned upon the CO giving appropriate notice to the contractor and the union. And there are some other little wonky rules in there depending on when performance starts, but it's a complicated rule. And so the rule of thumb should be aim for 30 days prior to the exercise of your option. So if you have a weird option period that's 6 months instead of your base year is 6 months instead of a year or something like that, this rule is still going to apply. So make sure that you get that thing in on time, or the CBA will get rejected and you won't get your price adjustment. You also have to negotiate at arm's length. Even though everybody in that room is likely to know that you will likely be entitled to a price adjustment for increases in wages and fringe benefits, you cannot say rub elbows with the union and say, hey, let's just get this done. You have an obligation to negotiate this thing just like you would a commercial contract. And that's really critical because every now and then the government will accuse a contractor of not doing this right. And then you end up at a hearing.
I just want to add one thing to the timeliness issue before we go to the next slide, just to remind people that just because your timeliness or your time has run out doesn't mean that that erases your obligation to bargain in good faith. So you want to be really careful about how you kind of convey to the union that you can no longer submit a price adjustment to the government.
Or that you don't want to negotiate for 6 months because it's not due for a year. We've had that happen too. You know, your duty to negotiate with the union is separate and apart from your timeliness to the government. You also have to be concerned about a substantial variance issue, which is another reason why you don't want to enter into some sweetheart deal with the union, because the government could challenge your rates and say that they are too high, and that it's a substantial variance with rates in the locality and therefore it's rejected. In that case, you would go to a hearing in front of an ALJ to justify your rates. There used to be an old Navy rule of thumb that you were looking in the 20% range as a maximum, but there's no regulation that specifically identifies what substantial variance is. And in fact, in many cases, a first contract with a union when a group is newly organized might have a bigger jump than in the out years. That's pretty common. So substantial variance is one of those things where if you think, oh, we're getting way out of range with what folks are normally paid around here, you should be concerned about a substantial variance rate issue. You also need to be careful about your effective dates. So we generally like wage increases to hit at the option year because that's when we're going to be entitled to a price adjustment for that option year going forward through the next year. But The regulations also require that you have a current effective date prior to the date of that option. And so there are ways that when we're looking at CBAs and negotiating them, we always like to make sure that CBA is effective before the date of the option and that there's a current rate in there, and that at the option years there are certain increases reflected. So if you have questions about how you do that, just give us a call and we can take a look at kind of what's being proposed. Most of the time it's not an issue in negotiating with the union. It's just making sure that you have it right so that it doesn't get kicked. And finally, we're concerned about contingency clauses. Anything in a collective bargaining agreement that says, you know what, if the health and welfare rate for SCA goes up under the regular wage determinations, we'll jack ours up too. Or anything that says this is contingent upon the contracting officer accepting the CBA. The contracting officer has the ability to reject a CBA that has contingency clauses in it. Again, the benefit to you is that you're negotiating this separately with the union and that your obligations with the union are separate and apart from your obligations to the government.
So what happens if, for whatever reason, you missed one of these many factors and your price adjustment is rejected by the CO? Do you get to just start over, go back to the union and say, hey, just kidding, I'm not getting reimbursed for these costs? No. Technically, you have an agreement. You have a signed contract between you and the employee's representative that you will provide employees with certain wages and fringe benefits, and you're going to be bound to that agreement. So that's why it's really important that you get it right the first time and aren't in a situation where you've promised to expend essentially more on labor than what you've provided to the government and that you're expecting to spend on the contract.
And next we have a timeliness scenario, and I'm going to suggest that you read over this and see what you think, and if you have any questions about it, you contact us so that we can get to price adjustments before we wrap up today. I also want, before we lose anybody, I want to note that we have a number of very good questions, and we will get back to you. Just with the time in this webinar, we're kind of running out of it. So we will get back to you on those questions we didn't get to.
Especially because price adjustment is such a huge part of all of this, and it would be really negligent of us to run out of time talking about price adjustments, because that's sort of the bread and butter of what this all means. So we've been referring to price adjustments sort of throughout as one of the big considerations that kind of feeds into labor relations and government contracting. And it's important to realize that price adjustments apply to the Service Contract Act just as much as they apply to the Davis-Bacon Act. That said, there are some differences between the two acts. With respect to the Service Contract Act, generally, assuming that the price adjustment FAR provision is in your contract, you're looking at this idea of a change in cost of labor. So you're looking at what you were spending prior to a CBA wage determination, and then after you engage a CBA, what you're spending after you've incorporated those new rates into your contract.
Which is the same as with a regular wage determination. It's just that now you have a different one and you have more categories to think about.
Exactly, because you've got all the different fringe benefits that are looped into the CBA. Under the Davis-Bacon Act, it's a little bit different just because you're not incorporating a CBA wage determination, but there are price adjustment provisions that exist there, including a percentage price adjustment that's a little bit off topic for today. But the moral of the story is you want to be careful to read what the FAR provision is and what it says in your contract before you assume how to do this.
And for some commercial items contracts and other types of contracts, there may not be a price adjustments clause in there because for the most part, any modification has to be done on a bilateral basis, at which time you would negotiate the price. So again, just go back and make sure when you're bidding on the contract and that you know which price adjustment clauses apply so that you can appropriately bid it and then appropriately get the wage determination. But you want to get these things in, so you're going to turn the CBA in, and then you're supposed to turn around a price adjustment to the government within 30 days. Contracting officers will usually be a little flexible on that, but it's a good thing to not let it languish. And then you've got to make sure that you have the documents and calculations that you need to support it, which the CBA is a pretty good start for that, but they may actually ask you for the actual payroll account because you're going to include taxes, payroll taxes, workers' comp. And there are some fringe benefits, again, that they may not pay for. So when you're negotiating that CBA, you need to be very careful that you're not negotiating costs in that the government might not pay for.
Or at the very least, when you are negotiating these costs, that you've budgeted it in your own budget. So, for example, if you're going to give people uniform costs that you want to provide them, you need to understand that that's great, but the government won't necessarily reimburse you for those uniform costs.
And we did get one question that's appropriate for this slide, which is, does the CO have a time limit? Well, it can depend on how you process that price adjustment. We have a webinar, by the way, just on this. So this can be a very heavy lift in and of itself for the price adjustment stuff. If you submit basically a request to the CO that's not an official claim, then they can languish. So you need to then go back and say, no, that this is an actual claim to you. And then that will kick off a timeline for them to respond to you. They're supposed to respond to you in, I think, 60 days. And then if they don't respond to you, then you can elevate it to an adjudicatory body in order to process that claim. Nobody wants to get there. You want to resolve these things generally at the lower level because then you could possibly even get your attorney's fees if needed. So I hope you all will join us next week. I know that was a very, very quick and dirty guide to things that you should be aware of. Again, we will follow up with those of you who had questions. This is an area of law where there are a lot of landmines, and I hope next week we will get into more about landmines in the negotiating area itself. So we hope that you will join us then. Thank you so much. Have a good afternoon. Half an hour goes very fast.
Oh my goodness. You were like 3 slides in. I was like, we have 20 minutes.
You have questions that you need that printed off?
Yeah.
Okay.
Yeah. Solely on the SCA. We do.
Oh, yeah.
I would like to talk with you. How do I contact you? AKA the email address is attached.
Like literally it's on the screen right now.
Actually,
Right?
just go
Maybe
back
not.
to...
Oh, go to the next one.
It says audience view.
Show screen.
Oh, thanks.
We'll get in touch with them. Yeah, if you can send us stuff, that
Sure.
would be good.
I'll leave that up for a minute. No problem. Was there something at the beginning before I turned up the sound where
Well,
people...
somebody said they couldn't hear, but they could have been there. But Holly said she could hear fine, and it was just one person.
Okay.
So
Because it was literally like I set you guys up. I ran to get the rest of my lunch out of the kitchen and then was headed back to my desk. And right as I sat down, I was like, wait, was there something going on? Because I can hear.
yeah, I mean, Holly said it was fine.
Okay. All right.